Members of the Senate are focusing on gun rights in the wake of the Supreme Court's Bruin decision.
Major Supreme Court ruling.
The U.S. Supreme Court has just issued a major ruling.
This is a case that's been bounced around back and forth throughout the court system.
It's a case that legal experts will be watching closely.
What happens when a federal judge declares a law unconstitutional, but the state keeps enforcing it anyway? Not for a few days while paperwork gets processed, not for a couple of weeks during a standard appeal, but for 18 to 24 months or longer, arresting people, denying permits, and destroying lives the entire time. You'd think that's impossible in America. You'd be wrong. And the Supreme Court just issued an emergency order that exposes exactly how states have been pulling this off for years, the tactics they've been using, the people they've been hurting, and the internal emails that prove they knew exactly what they were doing. This isn't a story about one bad law or one rogue state. This is about a systemic exploitation of the legal system that's been hiding in plain sight. And what makes it even more disturbing is how brazen officials have been about it behind closed doors.
There is a difference between states deciding how they want to regulate any number of things versus stripping people of their rights to self-defense.
Saying setting a higher threshold in an emergency could mean life or death.
Critical Second Amendment Preservation Act's challenge that was pending in front of their court.
For the Supreme Court, it's all about language, reasonable suspicion, objective reasonable belief, or probable cause.
Let me show you how deep this really goes. The Supreme Court's emergency order doesn't just acknowledge this problem exists. It calls it out directly and forcefully. It's essentially a warning shot to every appeals court that's been rubber stamping delays and helping states sidestep constitutional rulings. For too long, fundamental rights have been treated like privileges that can be postponed indefinitely, restricted arbitrarily, or simply ignored when politically convenient. This order signals that those days might finally be ending, but the surface level outrage barely scratches what's actually been happening. States discovered a loophole in the appeals process, and they've been exploiting it mercilessly. It's a legal delay game that sounds almost too cynical to be real, yet it's been working perfectly for years. Here's the formula they've been following with surgical precision. Step 1. A state passes a highly restrictive law that clearly pushes constitutional boundaries. Step 2. A federal judge examines the law, reviews the precedents, and issues a ruling declaring it unconstitutional. You'd think that's the end of it, right? The law gets struck down, rights get restored, everyone moves on. But that's where the real strategy kicks in. Step 3. The state immediately files an appeal and requests what's called a stay. That stay keeps the unconstitutional law active and fully enforceable while the appeal slowly winds through the court system. And here's the brilliant part from their perspective. Appeals take forever. 18 months minimum, often much longer. During that entire time, the law that a federal judge already ruled unconstitutional remains in full effect. Think about what that actually means. Citizens get arrested for exercising rights that courts have already confirmed they possess. Applications get denied under rules that judges have already declared invalid. Thousands of people remain trapped in legal limbo, their constitutional rights suspended indefinitely while lawyers argue over procedures. This isn't theoretical speculation. We can count exactly how many times this has happened. At least 14 documented cases where states use this precise formula. In 11 of those 14 cases, the strategy worked flawlessly. The unconstitutional law remained fully enforced from the moment it passed until the final appeal concluded. While legal battles dragged on for years, thousands of permits were denied, hundreds of people were arrested, and millions of citizens were denied rights that federal courts had already confirmed they held. Let that sink in for a moment. A federal judge issues a formal ruling that says this law violates the Constitution, and the state's response is essentially, we're going to keep enforcing it anyway. That's not how justice is supposed to work. That's not respecting the rule of law. That's gaming the system, pure and simple.
Everybody has a right, if they're a responsible adult.
Give us transparency in how you're going to handle them. And if there's a roadmap of what you're going to follow that's more clear, then it's going to be a fair process for everyone.
The right to keep and bear arms shall not be infringed.
My response to that is that's the same claptrap that they have been using for 20 years.
You couldn't get a firearm and carry it just because you wanted to be protected against criminals. We won't see changes overnight, but it's going to be quick.
Now, finally, the Supreme Court is intervening. This emergency order directly targets that tactic and forces appellate courts to ask a fundamental question that somehow wasn't being asked before. Is the state actually likely to win this appeal? If the honest answer is no, then enforcement should stop immediately. No more years-long delays. No more arresting people for exercising rights that courts have already recognized. Just basic fairness and constitutional compliance. And it sounds like common sense, doesn't it? But until this order came down, that simple question wasn't even part of the equation. And when you dig into how appeals courts have been handling these cases, the double standard becomes absolutely infuriating. When courts deal with stay orders involving First Amendment cases, they issue lengthy, carefully reasoned opinions. 18 to 22 pages of detailed legal analysis, multiple citations to precedent, thorough examination of the constitutional issues at stake. But with Second Amendment cases, that same level of care mysteriously evaporates. Some stay orders in these cases are just 2 or 3 pages long, barely more than a formality. One particularly infamous case reversed a 127-page federal court ruling with a stay order containing only 847 words and exactly 2 citations. Read those numbers again. A federal judge produces a deeply researched decision with 340 citations to legal and historical sources. An appeals court overrules it with a document barely longer than a typical blog post. Legal scholars have a term for this: conclusory decision-making. It means courts skip over the actual reasoning and analysis, then jump straight to their preferred outcome. And when a court can strip away your constitutional rights without even bothering to explain why in any meaningful detail, what kind of protection do you really have? But this isn't just about sloppy legal writing or procedural shortcuts. These decisions are devastating real people's lives in tangible, permanent ways. Consider New York's concealed carry law. It remained in effect for years after multiple judges ruled it unconstitutional. The requirements were absurdly invasive. Applicants had to submit 3 full years of social media history for review, sit through face-to-face interrogations, explain in writing why they needed a firearm, provide notarized statements from character witnesses. One questionable post discovered anywhere online could lead to automatic denial. Now imagine if you had to go through that process to exercise your right to free speech before posting a comment, or explain to a government panel why you deserve Fourth Amendment protections before you could refuse an unreasonable search. That kind of prior restraint on constitutional rights wouldn't be tolerated in any other context, but citizens have been subjected to it for years with these laws. And even after courts struck down these requirements, people who tried to exercise their restored rights faced arrest. In Maryland, 23 individuals were arrested after a court blocked enforcement of a gun ban in certain public locations. The judge's ruling was crystal clear: carrying there was legal. The state didn't care. Law enforcement arrested them anyway. Each of those 23 people now carries a felony arrest record. Criminal charges were eventually dropped in most cases, sure, but the damage was already done, their reputations scarred, background checks permanently flagged, career prospects ruined. Some lost job opportunities, others faced social stigma in their communities. You can't undo that kind of harm. In Illinois, a man legally carried his firearm in a public park after a court ruling explicitly gave him that right. Police arrested him regardless. The state attorney general had instructed law enforcement to ignore the court's decision. That man spent 14 hours in a jail cell, had his legally owned firearm confiscated, paid over $8,000 in legal fees, and waited 7 months before charges were finally dropped. By the time his name was cleared, he'd already lost a job offer because his background check was no longer clean. These aren't isolated incidents or unfortunate accidents. They form a deliberate pattern, a calculated strategy built on a cynical assumption. Most ordinary people can't afford to fight back. They don't have thousands of dollars for attorneys. They can't risk arrest records affecting their employment. They won't challenge a system designed to exhaust and intimidate them. And while all this has been unfolding, tens of thousands of Americans remain stuck in legal purgatory. Right now, at this very moment, over 47,000 concealed carry permit applications are frozen across 6 states. In California alone, more than 14,000 people submitted complete applications, paid all required fees, passed background checks, completed mandated training, and were simply told everything's on hold indefinitely. In New Jersey, nearly 9,000 applicants faced the same situation. They followed every single rule, submitted all the paperwork, paid hundreds of dollars in processing fees, and the state's response was essentially, "We don't know what law to follow right now, so you'll just have to wait." Hawaii might be even worse. Some applicants have been waiting over 23 months. Their training certifications expired during the delay, forcing them to start the entire process over and pay all the fees again. Others gave up completely and moved out of state, losing everything they'd already invested.
This case could reshape how far states can restrict your right to carry and where.
Throughout all these delays, states collected over $18 million in application fees without issuing a single permit. Let that number sink in. $18 million taken from citizens for a service the government refused to provide. But here's the most disturbing part of this entire story. They knew exactly what they were doing. We know this because internal emails from ongoing lawsuits have been exposed. The evidence isn't circumstantial or speculative. It's right there in writing. In New Jersey, state officials openly discussed in emails how requesting stays was their best strategy to keep unconstitutional laws in place for another 18 months. A California Deputy Attorney General wrote that they were confident the Ninth Circuit would grant a stay, even if their legal arguments were weak. And in New York, an internal government memo spelled it out explicitly. Even if they ultimately lost the case, the deterrent effect of continued enforcement made it worthwhile. They knew the laws were probably unconstitutional. They knew federal courts had already ruled against them, but they kept enforcing them anyway because they calculated that most people wouldn't risk arrest even when the law was on their side. One email even described the chilling effect on lawful behavior as a policy success. Make people uncertain about the law, officials reasoned, and they won't exercise their rights at all. Legal ethicists are now asking hard questions. Is this obstruction of justice? Is it contempt of court? Because when government officials deliberately ignore judicial rulings and punish citizens for obeying the Constitution, the system isn't just broken, it's being weaponized. With this emergency order, the Supreme Court has finally said enough. The emails are exposed, the delay tactics are documented, the human cost is undeniable. This is no longer just a legal dispute about procedural technicalities. It's a constitutional crisis that's been hiding in plain sight. Millions of Americans have had their rights delayed, denied, or criminalized by a system that wasn't broken by accident. It was manipulated deliberately and systematically. And for the first time in years, the highest court in the land is stepping in with a clear, unambiguous message. No more delays, no more excuses, no more games. That's it for today, folks. See you in the next video.